Good morning. May it please the court, my name is Jean Kempthorne.
Okay, hold on just 1 minute.
Sorry.
We want to get your comments on tape. And so, Ms. Mellon, all right, let's proceed.
Thank you. I represent Victor Young, the appellant. The defendant, Mr. Young, seeing his unarmed friend Jerry Hall dragged out of the back seat of a car and beaten badly, ran to his defense and stabbed his assailant, Mr. Hall's assailant, Wayman Pearson, who was a complete stranger to him, with a fishing knife.
Were the assailants using weapons?
Mr. Young would not have known whether they were using weapons, Your Honor.
Well, what we do know is he used a knife.
We do know that.
And no one else used a knife or a gun, or they were using their hands.
Correct, but the issue is not what they were using, but what he reasonably believed or feared that they were using based on what he knew. And what he knew, of course, is that on the way to Boston, they told him that they were armed. In fact, Mr. Pearson did.
Well, the defendant was driving the car.
Correct.
And so he didn't have to drive to where they were, did he?
You're absolutely right, Your Honor, but I want to invite the court to focus.
If he had said, you know, they're saying they're going to beat us up, why don't I just not drive there? And then there won't be a confrontation and no possibility of anybody being injured.
Your Honor, that is a very relevant inquiry, which the jury obviously resolved with respect to the altercation when Mr. Young gets out of the car, and that is the Morgan, Gibson, Francois altercation. But then there's a break. That results in an unhappy resolution where Mr. Morgan is severely injured, Mr. Gibson is accidentally hurt. The jury deals with that. And interestingly, what does the jury find? Mitigation. The jury gives the lesser included of assault with intent to kill instead of assault with intent to murder, meaning that they found, having resolved all of the issues that, Justice Ireland, you've raised, that when all was said and done, Mr. Young acted in something like self-defense or excessive use force in self-defense. Now let's focus on a new event. It's related because it affects Mr. Young's state of mind, but now he has withdrawn from Gibson and Morgan. That is resolved. He's looking to leave, and what does he see? He sees Hall being dragged out of the
beaten up.
Dragged out of the car and beaten badly. And Pearson, don't forget, is very drunk. Pearson had called in to Ms. Muller in the car and said he was armed. So, and this is all taking place extremely, extremely quickly. And so what happens? The jury finds no mitigation with respect to Mr. Hall. How can this be, given that they found mitigation in the more dicey situation on the other side of the car?
Well, except that he's the one being attacked on one, and he's entering voluntarily into another fight on the other.
Except, of course, there's really no question, and the Commonwealth concedes, that Mr. Hall is being badly beaten. In fact, the Commonwealth concedes in its brief that they say there's no harm, no foul on the instruction because they didn't disagree that Mr. Hall had the right to defend himself, and therefore Mr. Young had the right to come to his defense with deadly force. So we're in a situation.
Deadly force? With deadly force? Mr. Young had the right to come to his defense with deadly force? I thought that's the problem here.
Well, that's what's interesting, because what they argue, we're jumping way ahead. I'd really like to focus on the jury instruction, but let me deal with the prosecutor's argument, because I think that's responsive to your question, Justice Cordy. What the prosecution argues and why the judge's instruction is not harmless is that there is no right to mitigation here, even though they've allowed the jury instruction and did not object to the judge giving a jury instruction on excessive use of force in defense of another. What they say is it wasn't reasonable and proportional from the get-go, and therefore it was murder. And I submit that is exactly what is not correct about, because what they're doing...
He couldn't argue that it was unreasonable for him to do that?
I'm sorry, Your Honor?
The prosecutor could not argue that it was unreasonable for him to do that?
He can...
Isn't that a factual issue for the jury?
Well, what's a factual issue for the
No,
jury?
is it a factual issue for the jury?
It is, assuming that the jury understands that it mitigates
okay.
and doesn't go to murder.
Okay.
Exactly.
But if it's a reasonable issue, if it's an issue for the jury to decide, a factual issue, isn't the prosecutor entitled to argue the facts?
He's entitled to argue the facts, but what he does is he fails to acknowledge the mitigation. And so what I'm trying to indicate is that the argument is erroneous in that it tells the jury that if it believes that the force was not proportional, and bear in mind that the Commonwealth has already conceded the right to use deadly force because they've not objected to the instruction.
No, wait a sec. They haven't. As a matter of argument, they've conceded the right to use deadly force?
Your Honor, the way I read Walker and Espada is that if the Commonwealth believes that there was never a right to use deadly force at all, they should object to the instruction going to the jury. There shouldn't have been a jury instruction. But here, and in any event, clearly there was the right to use deadly force, and we're looking at the facts from the point of view most favorable to the defense. But what they completely eliminate any notion that when you use deadly force, that if the force is then deemed by the jury to be excessive, it doesn't go back down to murder, it goes to manslaughter. And the prosecution completely eliminates that. And the reason that's a problem is because the jury hears that in the most explicit terms. What does the prosecution say? If there are if there aren't at least two people wailing on Jerry Hall, the victim, then then it's murder. And this was never reasonable and proportional from the get-go, and therefore it's murder. Now, the judge doesn't give that instruction because she's decided to give the instruction on excessive force. Yeah. In other words, there it is. She then gives the Martin instruction, except she flips it around. She gives the standard instruction that Martin allows, which is you look at the vantage point of Victor Young. You say, what is reasonable for Victor Young to have believed was happening to Hall? Was it appropriate to respond to save him using deadly force? And then you have a justified killing. If you find that it was excessive from his perspective, a reasonable person in his perspective, then you mitigate it down to manslaughter.
Correct?
She does it correctly in very general terms first.
So, and you're saying because the prosecutor didn't do the same thing, that's a reversible error?
No, I do not say that, Your Honor. What I'm saying is the judge then misstates it. What we're really dealing with here, and we've come at it backwards, is an error in the jury instruction. You have a correct jury instruction given in very convoluted, reasonable person in this position, third person,
well,
other
it's the
person.
model instruction, isn't it?
I'm sorry?
It's the model instruction.
It gives that instruction, then she tailors it, and she names names, becomes specific. So, and this is where she gets it wrong.
And then was it also followed up by a correct recitation of the model instruction?
Much later.
Well, so
22 pages later.
The last thing the jury heard was a correct instruction.
Except without a full explanation of the excessive force. If you recall what the judge says at that point, she says, well, and don't look at this in a vacuum because I've already told you about excessive force. So, and the word she uses is excessive. The prosecution asks her for two corrections. And this is long after she's even gone over the verdict slip. This is at the very end. And they say, number one, the knife here was a dangerous weapon. And she had twice instructed that, an instrument, you have to look at how it was used and so forth. But no, the prosecution says this is a fishing knife, it's a double-edged knife, it should have been a dangerous weapon per se. And also, you left out something on excessive force, and that is that it can't be retaliatory, punitive, or excessive. Or any justification is gone. And that is where she needed to give the full explanation and doesn't, especially having given it wrong. This court has frequently said when an instruction is given correctly and then incorrectly, and there's a mix of correct and incorrect, the court needs to advise the jury that it's making a correction. Otherwise, you have no idea what the jury is relying on. And I submit that the most reasonable interpretation of what happened here is because the judge reduced the general complicated, in her own words, complicated instruction to the here and now, what you look at with respect to Mr. Hall, that's what the jury would latch on to. And why I'm saying that isn't harmless, I'm responding with respect to the argument of the prosecutor in response to the prosecution's argument that the error was harmless because they didn't debate that Mr. Hall was entitled to defend himself. That's why the prosecutor's argument, Justice Botsford, is relevant. It's relevant because they say no harm, no foul. But there is a foul here. And the foul is the judge never corrected the incorrect instruction, which was the most specific instruction. And second of all, the prosecution underscored it, and underscored it by completely eliminating any notion of mitigation. That once justification was gone, the whole ball of wax was gone. And that, I submit, shows that there is a foul here. There is not only a foul, but a harm.
Clarify for me, was there an objection by the defense to?
There was not.
So our standard is
Substantial
likelihood.
Correct. The more lenient standard. Mm-hmm. Correct. And
I thought and maybe you're saying the same thing and I'm just not quick enough to follow it, but I thought that the point of the Commonwealth, in terms of what you phrase as no harm, no foul, is that it was in response to the criticism of looking at, I thought what you were saying was there's a problem in the instruction because it's suggesting that it's sort of an after-the-fact look at whether a person actually had the right to use, that is, somebody in Hall's position actually had the right to use self-defense. And I thought what you were arguing was what should have been said was it's what would a person reasonably think Hall could do. And I thought what they were saying was that doesn't really matter because, of course, everybody knew he could, that is, Hall could use self-defense. I thought that's what it was in response to.
it may be me, Your Honor, who is not quite clear on the prosecution's argument.
I'm sure that's not the case.
But the way I interpret what they're saying, and it may be my misinterpretation, but the way I see what they're saying is they're basically taking the view that there never was any issue as to whether Hall had the right of self-defense. That, in fact, they had conceded it, which is the point I made earlier. They didn't contest the argument. But then when they go to argue it, they argue it in the way I just described, which is if there aren't two people wailing on Hall, then there's no right for Victor Young to have used the force he did from the get-go. That is totally eliminating the issue of whether Young, from his perspective, thought that a knife was necessary, because it's Young who has heard from Mueller that Pearson says he's got a gun. He doesn't know. This whole thing is happening so fast that he isn't processing. And, of course, his mental state is also affected by what just took place, whatever the court's view, Justice Ireland, is of the right or wrong of that. The jury did consider that mitigated. And he's, of course, in a state of agitation, so it's very important. It isn't mooted, Justice Bodford, just because Hall had the initial right of self-defense. The jury should have been invited to consider Young's state of mind, a reasonable person having been in Young's situation, and that is important. So at the close of the day, the jury is out a whole day, comes back with a couple of questions. And one of the questions is, this dangerous knife, we can find malice from the use of a dangerous knife. I submit to you that my argument is not merely hand-waving. I think what actually happened here is the instructions got so complicated that when at the very end, the judge tells the jury at the very end, you can infer malice from the use of this fishing knife, end of story, with no explanation of mitigation. The jury just seized on knife equals malice, we are done on that. And I believe that is how you can understand how this jury was so confused, because everything they heard from prosecutor and from the judge about the excessive use of self-defense was a garbled, confusing, contradictory mess that at no time did the judge ever sort out the mess.
And I know this is where we began, but if he drives there and gets the knife, or his girlfriend gets the knife and gives him the knife, and he jumps out of the car, we don't take that into account in terms of weighing all this?
The jury took that into account in weighing the Morgan altercation.
Well, I understand they did, but there is sort of I guess, a question whether in the larger picture he was entitled to any of this.
Well, Your Honor, it's certainly a jury question, and at this stage, when you're looking at the instruction, don't forget this has got to be looked at in the light most favorable to the defense.
Right.
And the defense evidence is that Morgan is the aggressor and tells him, get out of the car, opens the car. So, but I'm suggesting to you, whatever the merits of that, there's no question that Pearson and someone else yanked Hall out. So let's focus there. Because whatever the rights were with respect to Morgan, we're now in a situation a minute or a few seconds or some very short period of time later with an independent, essentially independent event with respect to Hall. Hall is in no way the aggressor here. So now look at, does Young not have the right to come to Hall's defense?
Well, the answer, I guess the Commonwealth concedes the answer is yes.
He does.
And
Correct.
so your argument is, well, if he has the right to come to his defense, then maybe he had the right to come and use a knife.
He had the right to use deadly force on these facts.
How do you reach to that?
And
Isn't that a jury question?
It is a jury question, but again, that would focus only on the question of whether or not the prosecutor's argument was improper. We still have the problem of whether the judge's instruction on mitigation, and that's the primary issue. But here's the evidence on that, Justice Cordy. Virtually everybody, with I believe one exception, says that Hall was being beaten on by at least two, if not more people. And it's uncontroverted that Hall vomited blood, had internal injuries that caused him to vomit blood for 2 days. I mean, he was very, very much beaten up. So I think deadly force was appropriate. And then it's really a question of, is it a total justification or is it mitigation? And I believe I have a very short amount of time. I would like to turn to the Section 33E issue. And I realize very well that 33E reductions are very scarce, scarcer than hen's teeth, but I believe this case calls out for a reduction. I believe this is a paradigm of a voluntary manslaughter case. Victor Young had barely any record when this terrible tragedy occurred. He was working at Filene's. His motive was never to get into a fight, but to stand up for his girlfriend's rights to get her daughter back. I mean, he may have acted foolishly, but that's what that was. It wasn't looking for a fight. It was looking to get the baby back. And the events bear that out. Mueller gets out of the car. Calvin, where's the baby? It all went terribly wrong. I believe this is a manslaughter case. I believe it is almost exactly like the Keogh case, and I urge the court to exercise its power and its discretion to reduce the verdict if it does not find reversible error, which we believe there is. Thank you.
Thank you.
Good morning, Your Honors. Paul Lynn for the Commonwealth. With me is ADA David Fredette, who was the trial prosecutor.
Explain this, Mr. Lynn. I'm very confused about this instruction stuff.
Yes. Well, the first thing I want to say about that is that there are, of course, two standards. One regarding whether the defendant is entitled to an instruction, and the second regarding what the prosecutor is entitled to argue in his closing argument. Okay. The justification for the instruction in that situation, the judge must view the evidence in the light most favorable to the defendant. If the evidence in the light most favorable to the defendant, even if it's completely incredible, justifies the instruction, the judge has to give the instruction. The prosecutor, on the other hand, is entitled to argue his case in the light most favorable to the prosecution. So the fact that the Commonwealth did not object to the instruction on excessive force and self-defense was in no way a concession that the defendant was entitled to that, and wasn't, actually acted in defense of another or acted excessively in defense of another.
Well, you say in your brief that it was uncontested that Hall had the right to defend himself. He was being beaten up by two people, and therefore Young had the right to come to his defense. Am I wrong about that?
That's correct. There's clearly a right to. There's clearly Hall has a right to self-defense,
and Young
has a right to come to his defense. There are two questions then. The first is whether Hall was entitled to use deadly force in self-defense, and the second is whether he actually acted in defense of another.
You don't mean Hall, you mean Young.
Yeah, I'm sorry. The names go all over the place. Yes. The question is whether Young was entitled to use self-defense, and whether Young, in fact, that was his motivation, was to defend Hall, or whether, as the jury found,
whether Young was entitled to use deadly force in self-defense.
Defense of another, and whether he, in fact, acted with that motivation. The jury found the defendant guilty of the murder of Wayman Pearson by deliberate premeditation, which suggests that they found that that was not his motivation. His motivation at that point was to kill Wayman Pearson. Regarding the jury instructions, the middle instruction, which is the challenged instruction, is not an erroneous instruction. What it is simply an accurate instruction that, if read in isolation, possibly could have confused the jury about whether this evidence was to be viewed from Hall's perspective or Young's perspective. But the judge twice, first immediately before the challenge instruction, and then at the very end of the instructions, at the prosecutor's request, gives the model instruction that the evidence must be viewed from Young's perspective, whether a reasonable person in Young's position would believe that Hall was entitled to use deadly force in self-defense. So the Commonwealth's position, this is not an Acevedo situation where you have correct instruction, incorrect instruction, correct instruction. That's the problem in Francis versus Franklin, where there's a correct instruction, there's an incorrect instruction, and the jury doesn't know what to think. Here you just have a model instruction, a correct instruction that could be misinterpreted out of context, and then a correct instruction. So this is not a Francis Acevedo situation. This is just a situation where the challenged instruction in context is not misleading, does not suggest otherwise. The prosecutor under Espada was entitled to argue that if the defendant had no right from the start to use deadly force in Hall's defense, that he was guilty of murder, not manslaughter. And the argument was that even though there was undisputed evidence that at least two people dragged him out of the car, by the time the altercation with Morgan and Francois at the front of the car is over, there's only one person left, and that's supported by the defendant's own statement, where he refers to the assailant as he and him. The defendant admits in his testimony that he never saw anyone with a knife. Although Pearson has a knife in his pocket, at the end there's no evidence whatsoever that he ever used that knife. No one saw him use that knife. No one saw him take it out.
But there had been talk of a gun.
There certainly had been talk of a gun, but there was also evidence in the light most favorable to the Commonwealth, which is, again, what the prosecutor can argue based on, that Jackie Badger, the baby's mother, had said, no, these people don't have guns. So in the light most favorable to the Commonwealth, the evidence is that he knows these people. There was also evidence that from Hall that he says, you don't have guns. You're from Beacon Hill. I'm from Orchard Park. In Orchard Park, we have guns. So there's certainly evidence in the light most favorable to the Commonwealth from which the prosecutor can argue that the defendant doesn't believe that any of these people are armed. He admits in his testimony that he doesn't see Pearson with a weapon at the critical moment.
But how fine a point does one need to put on it? In other words, if it's this melee and he's clearly being, as Ms. Kempthorne says, wailed upon.
That's undisputed.
Is it impossible, and he doesn't see a knife or another kind of weapon, but just in those circumstances it's not possible that one might think you need a dangerous weapon in order to end this wailing?
It's possible. That's why the defendant was entitled to the instruction. But the prosecutor was entitled to ask the jury to reject that inference, and the jury was entitled to reject it. And by finding deliberate premeditation, we can infer that they found that he went over there by this point just wanting to stab, wanting to kill Mr. Pearson. And I think that...
and that, you would say, is supported by his comment after the fact.
Yes, absolutely. I hope one of them died. So, regarding the prosecutor's argument, too, the judge clearly says in instructions, take the law from me, don't listen to anything that the attorney said regarding the law. But, as set out in his spot, this was a correct statement of the law. The judge ended up not giving that instruction, so the jury had to listen to the instructions as the judge gave them. But it was still a proper argument by the prosecutor. And the judge, the most important thing is the judge does give a very clear instruction on all three of the possible mitigating factors in this case. And the instructions on defense of another are quoted in my brief. And the judge clearly says, if the Commonwealth fails to prove that the defendant was not entitled to use defense in another, then it's not guilty. But if they prove that he used excessive force, then the verdict is manslaughter. So the jury hears these instructions. This is only 9 or 10 pages before the end of the charge when the judge gives the instruction. When the judge gives the instruction about retaliation and punitive and retaliatory intent, refers back again to the instruction on excessive force. Says, don't consider these instructions in a vacuum. Remember what I said about excessive force. That's not a quote, I'm paraphrasing. I'll take questions on any of the other issues. I would like to address the 33 issue.
Well, I do have one hypothetical
Yes.
question for you. If Mr. Young had observed Mr. Hall being beaten up by, say, 3 or 4 people, would that have been sufficient to support his use of a knife?
Again, the question is not sufficiency. The question is whether he actually was justified. Yes, the issue here is whether, under the circumstances, it was reasonable for the defendant.
So you say when he looked, there was just one person.
There was just one person.
So I'm giving you a hypothetical.
Yes. Certainly, if there were 4 people there, regardless of whether they were armed, that would be a greater justification. I think it would be hard for a jury under those circumstances, and very callous of them, to say, oh, well, why did he use deadly force? There were only 4 people beating up the guy. But where there's only one person, and the defendant is a very large man, of course, so is Pearson, that is a situation where deadly force arguably was not.
Well, one of these
justified.
people was 6'7", wasn't he, or 6 feet?
Yes, that was Lenny Gibson, who was involved in the fight in front of the car. He was one of the two people with Francois who came up behind the defendant. Pearson, the victim, I believe is 6 feet tall and about 190 pounds is how he's described. The defendant at that time is over 6 feet tall, weighs, I think he said, about 260. So he's a big man too. So these are two relatively evenly matched people. So the Commonwealth's argument, which I think is supported by the evidence and sufficient to withstand 33E review, is that there's only one person fighting with Hall at this moment. And it's, this is all supported by...
Even that's true, there's still people around. They've been
Yes.
there, they were there. I mean, this is a 2-minute fight.
Right.
From
It's a
beginning
very short
to end.
fight.
So this is a tiny piece of the 2-minute fight.
Right. We can't
Everything's
isolate
moving
it
quickly.
entirely.
There are a lot of people around.
Right.
There have been several people there
Right.
dragging the guy out and wailing on him. He's seriously injured.
Right.
So you're going to say, wait, those people are moved over there, so maybe I can get there and they won't come after me. I mean, is that how we look at it? Or we look at it, oh,
No, clearly you look at it
the whole thing,
in
right?
the whole thing. But the point is, at this
From his
point,
point of view.
People are scattering. He's fended off. Morgan has disappeared. Francois is on the other side of the car, and that was the point I was just getting to, is that he claims that he goes over and helps out Pearson at one point, but then he retreats, and it's only later that he turns around and sees the defendant attacking Pearson, or at that point, Pearson is leaning over the defendant's arm, and the defendant is punching him, which inferably is when he inflicts the fatal stab wound. So yeah, basically the defendant looks at this, he sees his friend getting beaten up, and he goes over and by his own admission stabs Pearson in the back, but the medical evidence clearly shows that he stabbed Pearson 4 times and inflicted these other 8 superficial wounds as well. Both the defendant and Hall say this single blow to the back was sufficient to get the defendant off of him. Again, the issue is not whether these wounds were excessive to kill the victim, because that's not what the defendant is claiming. The defendant is claiming that he needed to get Pearson off of Hall. And the fact that he admittedly stabs, or I won't say admittedly because he doesn't admit it, but the evidence shows that he stabbed Pearson 4 times, supports the jury's verdict that he wasn't motivated by just getting Pearson off of Hall. His motivation was he wanted Pearson to die. Not because he had this long-standing grudge against him, but because he was part of this group that had come to Gaffigan's defense and that he was beating up his friend, and that the defendant's reaction was that, I want this person to die. I want this person, all these people who are
He didn't say
trying
this.
to support a guy who stole my girlfriend's baby, to die.
Could you just respond to the argument that the malice instruction on use of knife had nothing to do with the outcome?
But it's
I
a
mean, I assume that's your
it's a correct
position,
instruction.
you
It's
could
the
tell.
instruction that
Right.
you may infer malice from the
Right.
use of a knife. To come to that conclusion, you have to conclude that the jury ignored all of the instructions on mitigation, which go on for pages. He talks about self-defense, talks about defense of another, talks about reasonable provocation, heat of passion, sudden combat.
Did she give written instructions to the jury?
The defendant?
The judge?
Oh, I don't remember. I would have to check that.
She wasn't allowing them to take notes.
Again, I would have to check that. I don't remember the exact circumstances. But she does give complete and correct instructions on all of the mitigating factors. And to say that the judge says, oh, yes, you can infer malice from the use of a deadly weapon, to that correct instruction to say, oh, wow, so I guess we can forget everything we heard over the last half hour, 45 minutes, is insulting the intelligence of the jury. Are there any questions about the prosecutor's argument? I think I've addressed those adequately in my brief. The Commonwealth's position is that these instructions were considered as a whole were correct and would not have confused the jury. And regarding 33E, obviously there are sympathetic factors in this case, but the defendant deliberately drives all the way from Sandwich to Boston.
Well, drives from Sandwich to Boston with his girlfriend in order that she can retrieve her child.
That's correct.
And the
He
first
knows
thing that happens is one of the girls gets out of the car and is looking for the child.
that is true. The evidence is that Mueller gets out of the car and says, "Where's the baby?" But he asks for a knife. He knows he's hearing these calls saying, you know, we better bring your burners. There's going to be trouble. He asks for a knife.
If you come to try to get that child, there's going to be trouble.
There's going to be trouble. He doesn't call Goffigan's mother, who usually cares for the baby. He doesn't call his girlfriend's parents. Given the route he describes, he drives within sight of the Area A1 police station, doesn't seek help there. He goes to the scene deliberately in the light, well, not only the light most favorable to the Commonwealth, but the weight of the evidence. Almost all of the witnesses testify that he gets out of the car and he attacks Morgan with the knife. So the Commonwealth's position is this was a situation the defendant could have avoided. This was not a spontaneous fight in which things just got out of hand. This was a situation where the defendant knew trouble was coming. He went to the trouble. He struck the first blow. And under those circumstances, this Court should not grant relief under 33E. Are there any further questions? Thank you very much, Your Honors.